Yes, Mr. Chasty.
My Lord asked about the resignation letters. We don't have them in the bundles. We've located a copy of Mr. Montaldo's letter of resignation, which we can provide hard copies of. Or it's about 8 lines. I'm quite happy to read it quite quickly, just so you have a flavour of it if you'd like me to. It's addressed to the directors. It says, please accept this letter as formal notification of my intention to resign from my position as director with CEL. In accordance with clause 2.1 and 14 of the consultancy agreement, my notice period is 6 months. Accordingly, my final day will be Monday the 10th of July 2023. I'd like to thank you for the opportunity to have worked in the position for the past 3 years. I've learned a great deal during my time here and I've enjoyed collaborating with my colleagues. I will take a lot of what I've learned with me in my career, and I will look back at my time here as a valuable period of my professional life. During the next 6 months, I will do what I can to make the transition as smooth as possible, support in whatever way I can to hand over my duties to colleagues on my replacement. Please let me know if there's anything further I can do to assist in this process. We don't have Mr. Blanchfield at the moment, but we'll seek to get a copy.
Thank you.
Well, could I just deal with a couple of points before just coming back to the OneDrive issue, although it does have an impact in relation to that. My Lords have made a number of points about what's left in this action if I win on breach and liability. I do stress, of course, that, as is obvious, that it was a split trial back in April last year. It was specifically teed up as a split trial. We've got a claim for damages or accounts of profits. We've had no disclosure. We've not pushed disclosure in relation to any of those issues at the moment. Can I just draw to your attention, for example, one element of breach, we say, but which also might impact on this question of financial repercussions. In my skeleton argument, I've set out at great length the various activities and actions taken by the defendants. And the Lords have said, of course, that you've read my skeleton argument and many of the documents that I've referred to in it. So I'm very conscious I'm not going through the detail of that in my oral submissions, but the dates that we've set out in my skeleton are very important. They show activity from a very early stage in terms of different parties that they're dealing with and the various things they're doing. And we've tried to provide that by way of a chronology within the skeleton. At paragraph 27, perhaps just one point to emphasise. We refer to a company called Impact or Claims Experts. As I understand it, this is a company which effectively gathers potential clients. It harvests them almost by its own process of gathering potentially interested parties, and then it passes them on to people such as CEL to then carry out the legal work. At bundle bear with me 1 second. At bundle 5 at 2894, page 2894. This is just an example of what we know so far, which is only half the picture. But at 2894, you can see that this is an NDA and confidentiality agreement between D3 and the Claims Expert Limited. And in fact, and I think again this is common ground, to add a little bit of insult to injury for my clients, this is a plagiarised copy of the NDAs that my clients produced. The only difference being that Mr. Blanchfield thought 4 years protection was required for MTCC rather than 3. But if you look at page 2908, you can see that it's signed by Claims Experts on the 22nd of September.
2908, did you say?
2908. Yeah. You can see it's signed on the as early as the 22nd of September. If you then please go back to see, you can see, just to see the structure, you can see at 2897 we have the agreement, we've got the parties, MTCC MTCC is the disclosure, got the claims expert. And then if you look at page 2900, we've got the purpose of providing information. And the purpose is described as being the evaluation, setup and completion of the marketing campaigns to obtain clients by way of high volume leads that will turn into clients with financial claims to the Financial Ombudsman Service in the UK that will then be run as claims. To facilitate this, MTCC will disclose confidential details of their department, infrastructure, intellectual property, processes and workflows that they use to successfully process and run complaints to banks and financial institutions, Financial Ombudsman Service and the courts for complaints and litigation in relation to bank payment recovery and high value loss financial complaint products that the disclosure may develop and any information obtained in the running of that department. The department and claims will be run, I think that's by MTC Solutions, and if a deal is entered into, the Claims Experts Limited can also run these claims using the intellectual property obtained, which cannot be used or transferred to any other person outside of the organisation. In respect of the disclosed claim types, the parties will enter into an exclusive agreement whereby the recipient will market for clients for the disclosure in respect of the above claim types exclusively pursuant to a joint venture profit share agreement with the aim of obtaining a portion of the market share for these products, complaints or claim types. It was our case, of course, and is that that information that's being referred to there as the confidential information of MTCC is the information that they lifted for my clients. In terms of
So what information?
Sorry?
So what information?
Sorry, the confidential information is described at 2898, but you can see that the purpose is they're going to give claims experts information for these various purposes, and the information is the information that's described at 2898.
Sorry, what's the 2898?
And you can see it's also, Lord, where they describe it, they will disclose confidential details of their department, infrastructure, intellectual property, processes and workflows that
Well,
they
that couldn't
use.
have been lifted from your clients.
Well, that was our...
Well, the judge found that there was very little in your client's figures that actually was represented confidential information, trade secrets, or anything like it.
I'm not trying to argue whether it was or it wasn't confidential information at the moment, but that's just a description that's being used. The information that's being referred to there, we contend, is the information that was taken from the claimant's files. Now, I'll come back to this. I merely want
Claims files, but information of what?
marketing, names and addresses of clients, fraud questionnaires, the whole documentation that they created and used over a 2-year period, plus all the expense they incurred in achieving that, to be able to then operate this kind of business in terms of these sophisticated financial fraud claims. So I merely want to draw to your attention that as at the 22nd of September, there is evidence that D3 entered into a contractual agreement with claims experts whereby information would be provided to it, and there would effectively be, possibly in the short term, a sharing through a joint venture of business in order to derive income and profit. So in other words, Impact Claims might do some of the work itself, and then there would be this joint venture sharing arrangement. Now, we don't have at this stage, we didn't have disclosure, we haven't pressed those points, but it's a potentially important area that I can't give you at the moment chapter and verse on, but it's one of the points that was a matter of concern, and the judge himself acknowledged in his judgment that it was a split trial. He said that at paragraph 202. He said that we highlighted some elements of possible loss, and he said, I can't possibly deal with that now though, because these are matters for another time. And in his judgment, he touched on this position of impact claims at 252, paragraph 252. page 110 of the core bundle. 252, he says, I don't find on the balance of probabilities that Impact began to promote for fraud and scam claims on their website after Mr. Smith met Mr. Blanchfield and that those web pages were later concealed. I've been referred to screenshots taken from Impact's website and dated the 27th of March and the 23rd of January, but in my judgment, it would be unsafe to make such a finding without additional evidence. Now, we haven't got into that additional evidence at this stage. We haven't got into disclosure. We've not issued any third-party disclosure applications if we have to against Impact, also known as claims experts. Those are matters which we would, if we leave this court with finding of breaches and so forth, wish to then explore and investigate. On the OneDrive, can I introduce the point about the OneDrive in this way? If I could ask you to look at what the evidence of Laura Hampson was about how these screenshots came to be known about, then it may answer, in fact, some of the points that my lord was making, which I was struggling to answer. If you look in the supplemental bundle, please, her statement begins at page 137. But it's at page 149 that I'm most interested.
This is
Page 149.
Supplemental.
Sorry, yes.
No, I think you did say, sorry.
And it's paragraph 44. It's under the heading True Extent of Theft of Documentation and Client Breaches. And she says on the 17th of March, paragraph 44, on the 17th of March, I was called into Paul's office. Jessica, who was now sitting at the desk previously used by Tom in Paul's office, was present, as was Paul and Andy Miller, our IT provider. Jessica told me that Andy was updating the computer used by Tom, and before wiping Tom's computer in order to repurpose it, he had asked Jessica if anyone had checked if anything was saved locally. Jessica had said no, so Andy checked it. The screen was on, and Andy and Jessica asked me to look at it, with Andy explaining that on looking on the local drive, he discovered a personal OneDrive which appeared to store hundreds of company documents. Andy explained to us all, since we had no real idea what a personal OneDrive was, that a personal OneDrive can only be on a computer if it's been downloaded by the user. It's a personal file storage facility. He could show me that it was Tom's OneDrive, since it was visible when Andy logged onto the computer using Tom's CEL email address user details, but it was protected by a login procedure. This was his personal Hotmail address and a password. 47, as he showed me the various screens, I could see hundreds of documents by title, which appeared to be CEL's documents, precedents, workflows, processes, training manuals, marketing materials, and most disturbingly, client detail. Paul was horrified by the scale of the data theft, and Jess was visibly upset and asked me to take screen grabs of the various screens to share. Whilst I'd been told by my solicitors that I shouldn't refer to documents which appear in the trial bundle unless it's necessary, I do think I should explain what's clear. 50, my understanding is the screenshots show essentially a snapshot of data stored as at the date it was last accessed from Tom's machine. Given the computer hadn't been used since Tom's departure, and that the personal OneDrive, as I explained, was protected by Tom's personal email address and an unknown password, I believe it shows data stored in those files on around the 13th of January, the date on which we asked ETI to remove Tom and Mark's access. I should also add that the firm is unequivocal about documentation and storage. Everything without exception is saved on the firm's N drive. She goes on. And then what she does is she explains the various files that are shown on the screenshots. Again, just before I come on to making any submissions, just so you've got the context of seeing the screenshots that she's there referring to, could I ask you to look in the supplemental bundle at 2260, please?
Give me a list of reference.
2260. And you can see that this is what she has just described that I've read to you from her witness statement, that she saw on the screen on Mr. Blanchfield's laptop. You can see in the top left-hand corner, OneDrive personal. And then you can see that a little bit below, about 7 or 8 lines down, OneDrive personal. And then what the column in the middle shows is the files contained within that. So you can see, for example, about halfway down, fraud claims funding pack zip 24th of August, marketing zip 24th of August. Over the page, 2261, about the middle of that middle column, fraud claims funding pack. And then you can see what came up as she's explained it when trying to open that particular funding pack. You can see it says verify your email and use your password. And then just a couple of more references, please. At 2262, you can see in the middle of the middle column, CC, which we understand is complex claims, fraud funding pack marketing, and then finally at page 2264, we've got a number of files, about 5 or 6 lines down, fraud claims funding pack 17th of August, fraud claims funding pack 1, 1st of September, NDA agreement, there's the same date as the date that Impact Claims signed on the 22nd of September, CEL, HDR training, and so forth.
Well, what would be interesting to know is what the defendants said when you cross-examined them about this stuff.
I didn't cross-examine him in any great detail. The reason being because the evidence of Laura Hampson was not cross-examined. It was
yes, but the evidence is what she saw. What it means is something only Mr. Blanchfield did.
Yeah. I think from recollection, his whole evidence was he was merely sending himself documentation that he was accustomed to doing as the accounts director, and that he did these things in order to assist him. He looked at the points and then he sent the material back. And I questioned him and said,
you would say to him, look at page 2265. There's a file called CC and Impact. What does that relate to?
I can't remember. I'd have to look at the cross-examination to get the details of where I asked him about these documents. But we did not cross-examine in great length because my client's evidence as to what they found, which we say pointed quite clearly to these documents being on his OneDrive, was not as such challenged.
So these are email attachments. These documents, last 2 pages, are all email attachments.
Yeah.
I mean, so to take my lord's point, I mean, the question is just, okay, so there's a load of email attachments that appeared on the OneDrive, but, I mean, the point is, you know, what's the explanation for what they are or what they might have been attached to? We were content to proceed on the basis that we had raised in our particulars of claim concerns about all of the emails that he was sending to himself, and he chose specifically, rather strangely, not to respond in his defence to that particular paragraph. And I did cross-examine him about the absence of him providing any answers.
Doesn't the judge deal with this at paragraphs 264 to 273 and then 279?
And so you have at 270 the rather unsatisfactory observation, because he doesn't really provide any details. He says at 270, the increased regularity and timing of some of the emails, etc., tied in with an intention to use them for his own purposes later.
Well, that's what you've been saying.
It is, but then he just completely rejected my case on the OneDrive, and he didn't take his 270 anywhere.
So we had explained to the judge, and we thought that the evidence was compelling from Laura Hampson, or at least required it to be effectively admitted and treated possibly as a matter of weight, but rather than almost being treated as inadmissible evidence. So he acknowledges at 270 that there was a motivation on Mr. Blanchfield to send to himself emails with documents to use in the future, but doesn't seem to hold that against him in any way. Nor does he actually identify what he means by towards the end of his time.
Well, I think that, isn't what he says at 279 where he ends up? In this question?
But that's again not that goes to remedy rather than breach. I accept and find any documents he emailed have now been deleted. That doesn't really answer the point that we were making.
So what is the point you're making to us?
The point that I'm
we
making,
are, as you know, concerned with remedy.
quite. The point that I'm making is that the judge, it's another reason why the judge was wrong on his approach to the Springboard injunction, because he had a mass of information which he simply ignored, showing improper activity. That's, I think, the answer, my lord, to my lord's point. That's why we say that the judge was wrong to disregard in this blanket way in which he did all of this evidence as to the OneDrive, and not to draw adverse conclusions as against the defendants. I've already taken it, and my lord's just gone to the paragraphs I was going to go to in the judgment, which deal with this question of apparently not being comfortable about the evidential route.
Yes.
But there's nothing particularly in our submission to cause the judge to feel uncomfortable. I think the only concern was the fact that we had at one stage sought to provide some assistance to the judge by also bringing Mr. Muldoon along to answer any points that might have arisen. The judge said he wasn't happy with that, and we didn't push the point because we had this lay evidence, we would say.
But he recorded at 276 that you said you were going to bring a further claim. What happened to that?
Where we were at that time is there was a huge amount of concern about the risk on exposure of breach of GDPR, the breach of the data protection regulations. There was a very, very deep concern there. And we explained to the judge that involved concerns that we had as regards insurance cover and protection for CEL, because the potential scope was enormous if there had been data breaches of thousands of individuals disclosing their names and addresses and telephone numbers to third parties. So there was a very real concern. What we tried to do, and I'm struggling a little bit with the detail because I was not, other counsel were focusing more on this point. We produced, I think shortly before the trial started, a draft of an amended pleading to bring in the GDPR elements and aspects, which the judge wasn't having any of, putting it fairly bluntly. And therefore, I think we simply said, well, we're going to have to wait and see where this goes in terms of what's thrown up. And that's why I've said, as I said earlier, my instructions are at the moment that insurers did get involved. It did require various steps to be taken as regards dealing with the fallout from the position. And my client's insurance premium has gone up by about 60,000 a year as a consequence on this.
Okay, just I'm sorry to keep coming back to this, but it does seem to me that this very odd aspect of this part is that you're not suggesting the judge stopped you or prohibited you cross-examining Mr. Blanchfield about these documents.
No, I'm not. But I went as far as I felt I needed to go. I explored with him his explanations that he was doing things just in order to facilitate his own ability to carry on his job. There was no challenge to what we'd found on his OneDrive. But the judge nonetheless just said, not because of any failure on the part of cross-examination or the part of any absence of explanations from Mr. Blanchfield. He just said he wasn't comfortable with it because we tried to produce some expert evidence, not pursued it, and then explained the evidence of Mr. and Miss Hampson.
So, to pick up my Lord's point, I mean, if your real criticism would have to be that the judge failed to give any weight to the evidence that you managed, or the answers that were given in cross-examination. I mean, it's where you put the, I mean, you're saying there's an inference to be drawn from what's been seen on this personal OneDrive. That's your case. It's that, look at all this stuff on this personal OneDrive. It includes lots of things which look like CEL's files. The inference, you say, which is to be drawn, is that they were being prepared for misuse by Mr. Blanchard after he leaves, yes?
Well, it's not just the inference. At 270, it's what the judge accepted was probably the case. He says himself.
Yeah.
But he doesn't say what he does with that finding at 270. He doesn't say why he doesn't think that in any way is improper or inappropriate to be taking our information to use himself in the future for his own benefit.
No, he doesn't, but he does say it's all been deleted and it's not available for use, and that's in the context of considering what relief he's going to grant.
Are there two different categories of, aren't we talking about two different things here? There's the documents that he emailed to himself, which the judge does deal with.
Yeah.
And that's what he's dealing with at 279. And then there is the OneDrive documentation, which the judge says that he doesn't consider it appropriate to take it into account. And what the judge said what the judge says at 270 and indeed 279 are the emails.
I think that's probably right, because at 276 he just basically seems to say, I'm not having anything to do with, I'm not interested in OneDrive at all.
And that's in part because you said you were going to bring a separate claim in relation to it.
That was only in the context of me talking about GDPR. That
Well,
was
he
in
says
the
it would be
context to say,
It'd
sorry.
be unfortunate if I sought to determine unpleaded issues overlapping with issues being addressed in anticipated litigation.
Yeah. The only further claims that we were going to bring, apart from a damages claim if we'd been successful, was in relation to GDPR. But we were relying on OneDrive as we hadn't pleaded it, of course, because it didn't come out until the middle or the end of March, 17th of March rather. So we were only 2 weeks off the trial at that stage.
See, I don't think he has made any findings as to the inferences he draws in relation to the OneDrive documents.
No, I don't think he has. Beyond, he doesn't, and the reason he does is I'm going to disregard it completely. That's the problem.
But that he wouldn't be able to do that, would he, if you cross-examined him?
But we did cross-examine to the extent of all the explanations that Mr. Blanchfield gave was everything he did for the purposes of enabling him to carry out his own job properly. And all the argument was, on behalf of Mr. Blanchfield, was that that's the position. He's not done anything wrong and he doesn't need to go any further in terms of dealing with these matters. And we left it on the basis that if that's how Mr. Blanchfield wanted to respond to the allegation, then we were entitled, in the absence of any cross-examination of anything that had been said of Laura Hampson or Paul Hampson, we were entitled to make our submissions.
I mean, I don't want to get too much into the detail, but the judge says at 272 that the OneDrive was, this is right, the OneDrive was your primary focus in relation to OneDrive was these 59 attachments that were unsuccessfully sent by Mr. Blanchfield's by Mr. Blanchfield to himself on the 8th of December 2022, is that right?
Yes, I can give you the page references if you wanted to see the email. There's an email where he tried to send a huge number of attachments, I think it's 59, and it failed.
Is that the extent of the OneDrive point? I mean, because there's a lot of the stuff here that you just showed us on the OneDrive that you took us to is predates. At least it's modified predates.
Let me rather than try to remember off the top of my head what this email says. The email, I think, is at page 2078. No, I think that's fortunate. I think that's wrong. 2003 possibly. I think the wrong reference has been put in. Yeah, 2003, isn't it? If you look, please, at 2003. Those are the attachments that he tried to send to himself and failed because of the number of them. So the Lord's right that the OneDrive files are different files from that email. So, some of them, I think. I haven't tried to cross-reference every one.
Yes.
So, sorry. And the entries on the OneDrive, as I've shown you already, contain the dates of the various files being opened. So, in terms of his refusal to consider the OneDrive issue, which therefore inevitably impacted on his approach to considering whether or not to grant Springboard relief, we say he was wrong in that respect to reject that evidence for all those reasons. And even when you look at such as he did accept at 270, taking the point, he may well have deleted those matters at 279. One can see that might go to the question of Springboard, if that is the factual position. But it just ignores, as I say, the rather important files that he didn't, we say, have. And the evidence would have shown in respect of the OneDrive. In terms of...
Did you seek disclosure of the documents on the OneDrive?
Sorry?
Did you seek disclosure of the documents on the OneDrive?
No, no, we didn't do it. Yeah, we found out on the 17th of March, and we were content with the descriptions of both. I haven't shown you the end drive, but I could give you the reference, my lord, for the end drive. And Laura Hampson has dealt with this in detail. The descriptions of the files are the same, and the size of the files is only slightly different because the end drive is, because of updates to the end drive. So we say that looking at the two side by side, there wouldn't have been the necessity to ask for disclosure of the OneDrive. Can I move on, my lords, to, I said I'd be about an hour. If I can move on to try to keep to that promise. I've covered some of this already. In relation to the decision of the judge not to grant an injunction in respect of the restrictive covenant 13.1, at 393 of his judgment, he deals with 13.1. This is the only one that I'm concerned with. And I remind my lords that the relevant clause is at page 263 of this same file. He says, clause 13.1 is a provision which in essence prohibits the defendants from supplying or soliciting any person with a view to supplying to clients of whom they've had material dealings during the course of their consultancy, services of the same or similar. In my judgment, the clause is plain in its meaning. 395, I'm satisfied it protects a legitimate business interest, namely the custom of its existing client base, which the defendants had material dealings. 396, the provision is reasonable in its scope. The covenant's restricted to clients and customers whom the defendants had material dealings. They will know the identity of those clients or customers. The clause doesn't extend to the entirety of the client base. The prohibition is reasonably short. He then says it's a non-solicitation clause, not a non-competition clause. I'm sure he's entirely right about that as a matter of construction, but in any event, he says at 397 he finds it reasonable in its scope and there's no reason in principle why the defendant should not abide by it. Then he says at 398 he's not aware of any evidence that they've sought to solicit. No examples of such solicitation. No threats to breach this covenant. I said before, my Lord Snowden said, well, it's customary to go with evidence. Well, we didn't have evidence of that, but to say there are no threats in the context of what evidence we did put before the court, in the context of since the middle of August, we say, without telling us, and in circumstances we say misleading us in relation to Deminor, they were doing all sorts of things which they shouldn't have been in breach of their obligations. And to say, therefore, there's no threat to justify an injunction in our submission
There's a difference between competing for future clients and seeking to solicit existing clients.
Yes, there is.
And I think the judge's point was that given the nature of this business, there was no actual or threatened attempt to do business with existing clients. And where it's difficult to see in this case how they would have such an intention.
Well, they had. Our evidence was that they had all of the customers' names and addresses, and those might be at different varying stages of progress of a claim, and you might offer better terms to clients. But there was, for the purposes of granting a negative injunction on a negative covenant, in our submission, the judge was putting the bar unreasonably high to come to court to justify simply holding the defendants to their bargain. And he concludes at 400 by saying, in those circumstances, in the absence of any violation or threatened violation, or any other unconscionable behaviour, it's any other, i.e. distinct from violation or threatened. The unconscionable behaviour in our submission was abundant. There was masses of unconscionable behaviour.
Leave that out of account for the time being. Is it your submission that where A enters into a negative covenant with B, B is entitled as of right to an injunction, irrespective of whether A has breached or threatened to breach the covenant?
I don't think the courts would entertain somebody who just turned up and asked for an injunction.
So when the judge says that there's no evidence of breach and no evidence of threat, that would have entitled him to refuse an injunction.
Well, where we say he went wrong, though, is saying that there was no evidence of threat. I accept there was no evidence of a direct attempt to solicit. But in circumstances where, in our case, the evidence is there was a settled intention to compete, they'd been trying to get their ducks in a row, we should have been given this extra level of protection. Certainly, if we weren't going to be given a springboard, we should have been given this extra level of protection that they had bargained for, so that we don't have to be constantly looking over our shoulder.
But that's the point my Lord Justice Phillips put to you. It's one thing to say you shouldn't be competing using a springboard or just competing for new custom. it's another thing to say you need to be protected by injunction against solicitation of existing clients.
Well,
And
I think it goes further with respect than just solicit. If you,
well,
supplying or soliciting, dealing with this. Although he said it was a non-competition clause, or
all right,
not convinced it is.
the difference is between, it's perfectly clear, however you frame it. One is the clause is dealing with people with whom you have dealt whilst you were employed by the or director of the company.
Yeah.
I clients of the existing clients of the company. I mean, that's what the clause says. I mean, it actually has the classic carve out as well. I think that if you haven't dealt with if you as a consultant have not had material dealings with the client, then you're entitled to it. The mere fact they're an existing client of CEL doesn't.
You can't have every single client that the defendant may never have heard of. Yeah.
So it emphasises that the point is it's dealing with people selected from the existing client customer base. That's a very different concept from going out into the marketplace and getting new business from new people.
It is.
Right.
It is.
So if the judge says there's no either violation or threatened violation of dealing with existing clients, and you accept there's no direct evidence, the only basis on which you could conceivably justify or support that is, to use the judge's word, evidence of other unconscionable behaviour.
And that is essentially what I'm doing.
It would lead to an inference that, in fact, that's what, absent of the injunction, they would have done.
And if one's looking at balance of convenience and so forth, then we would say perfectly, we should have had that extra level of protection.
It's not balance of convenience.
Well, we're just into a negative covenant here. But the proportionate relief to have granted should have been, well, at least you can have 13.1. I'm not going to give you a springboard, but I'll give you 13.1.
The judge has to conclude that there is, in fact, a reason to injunct
Yes.
a breach of 13.1.
Yes.
And the only basis on which you can do that, in the absence of any direct evidence of threat, is that that is an appropriate inference to draw from other behaviour.
Which we say existed, and he should have taken that into account. We have a massive evidence of them behaving behind claimant's back.
This is ultimately an evaluation by the judge, isn't it? And ultimately also an exercise of discretion.
But in doing so, in the evaluation, he seems to have completely ignored all the evidence with respect. He ignores all of that evidence described as other unconscionable behaviour.
Well, you can only get an injunction if there is a breach or a threatened breach of this particular clause in its particular terms. You can't get an injunction in the terms of clause 13.1 because of some completely different unconscionable behaviour. So to pick up my Lord Justice Phillips's point, and in fact indeed my Lord Justice Snowden's point, you were asking the judge to infer from what you say was unconscionable behaviour in other areas of the defendant's activities that they were threatening to breach clause 13.1.
Yes.
And he declined to draw that inference.
He did not take into account, we say, when he posed himself, or rather when he concluded that there was no evidence of other unconscionable behaviour. He clearly did not take into account in saying that everything else that we're arguing about. Transferring emails to yourself for the admitted purpose of using them for your own benefit in the future. One that the judge himself concluded at paragraph 270. Sorry,
I spoke over you. Apologies. That depends upon the content of the emails that were transferred. I mean, if the emails or the documents that were transferred had nothing to do with our existing clients and customers, but would have been for an advantage for a new business to solicit new business,
I see, yeah.
Then maybe.
I think my point is as simple as this, that these two individuals were clearly shown, and the judge gave no real weight to this at all, shown to be two individuals who were working in secrecy, working behind my client's back for their own personal benefit. And those individuals who were prepared to do that the judge in our submission should have taken into account, and if he'd properly taken into his account, he would have said, and ought to have said, I think the right thing to do is give you an injunction in terms of 13.1. That's my position.
Yeah.
And then the other points that he makes are equally bad. Damages being an adequate remedy, effectively. Those are just wrong points in our submission for the reasons that I sought to address before. Then Springboard, he deals with this at 468 onwards, and he sets out the various positions and contentions. He then sets out at 480 onwards the law, which I don't think one can take a great deal of exception to in terms of him quoting from various authorities, for example at 483, which is to restrain somebody who's gained a head start from taking advantage of the fruits and so on and so forth. And then he carries on with that. And then at 486, in our submission, he just completely understates what it was that the defendants were doing and the head start and the advantage that they were securing for themselves since the middle of August. And that's why, again, I don't want to take my lords to it. It would take a long time, but this is why we've set out in as much detail as we have in our skeleton the dates of all the various exchanges from mid-August through to September, etc., all the way through to the middle of January. The time with Deminor, the time, for example, with the Solicitors Authority. They started this. They started that exercise, my lords, with an email that we're aware of on the 30th of August. It was the 30th of August that they first emailed the SRA in respect of an application with a stated live date of the 6th of January and with a figure of an estimated turnover of 178,000. And that's all in our skeleton argument with those references. And it took from the 30th of August, for example, to, I think, the 6th of January for the SRA to come back and say, we're minded to move you to the approved stage. So that alone was September, October, November, December. That was 4 months alone to get to that stage. Forgetting, of course, all the details with Deminor. And that's why, my lord, at 493, so at 491, sorry, is talking about first contact with Deminor on the 9th of September. 492, the total period is 4 months. Then he just speculates and says if the defendants had waited until they'd left CL, the period would have been shorter. Not even might have been, would have been shorter, given that they'd be able to focus their energies on their new business and in no way constrained by their obligations to CEL. And then he just, my respect for him, he just really plucks a figure.
What else was he supposed to do?
Well, he's supposed to look at the facts and say, what I do know is that it took from the 9th of September to get the memorandum of understanding, which is 4 months.
Yes, but he's explained why he doesn't just take that as a bald 4 months in 493.
It's just that's just a statement. He can't. There was no basis for him to conclude it would have taken longer. He doesn't know how long Deminor might have taken to respond to points, or for Deminor to hold their meetings internally to deal with things. All I'm saying is he can't. Nobody put that forward as a fact, my lord. Nobody put that forward as evidence to say if they'd been free or freer to deal with things on a 9 to 5 daily basis with Deminor, it would only have taken 2 months to get to Deminor to the MOU stage. There was no evidence in support. That's just saying, well, it might have been quicker. But he makes a finding that nobody argued for. He says at 496, I see no evidence of any head start having been achieved by sending documents to his private email address. Well, then 498, he says in relation to banking, no bank account was set up. An account was set up with Lloyds. An account can be opened in short order. Business plans.
Is he allowed to say that?
He's allowed to say, yes, of course, my lord, he's allowed to say that a bank account can be set up reasonably quickly. But having said that, we do know that they struggled to get a bank account because they did try to get with Virgin Money from the 1st of, they started on the 1st of
Yeah,
September.
they got nowhere with Virgin.
I'm sorry?
They got nowhere with
Nowhere
Virgin.
It took them a long time to get the point I'm making, my lord, is it took them a long time to get nowhere with Virgin. So then they focused on Lloyds Bank, and they got the position set up with Lloyds Bank, I think, on the 28th of November. So he's wrong, in fact, to say a bank account can be set up in short order. This was not the experience of these defendants in this brand new case.
It was with Lloyds.
So
It was with Lloyds by the sound of it.
well, they started with Virgin. I don't think one can just say, in hindsight, they should never have started. They did what they did, and we know this is how long it took them. That's my point. That's my only point.
Yes, but you have to look at the counterfactual, don't you? Not just looking at what actually happened in their preparatory period. The judge has to make an assessment of how much that saved them had they been starting from scratch in July
And the
23.
well, the evidence is we would say, based on the evidence, they'd have gone to Virgin Money and they'd have wasted several weeks with Virgin Money. There was nothing by virtue of the fact that they were still directors that in any way caused them to still be and exhaust the lines of inquiry with Virgin Money for several weeks. That they wouldn't have obviously happened if they'd not been directors. I think that's
one of the big factors, of course, is that at the preparatory stage, they may well not have been in a rush. Whereas once they left, and come July 2023, they were obviously going to have to get things done very quickly to start trading.
they didn't put a case on that basis. They didn't defend a claim for a springboard on the basis of saying we could have done all of this in a week. We've gained no advantage. We could have done it all in a week.
That is pretty much what the judge is saying, isn't it?
But my point is, he's got no, beyond just saying this is what I think might have happened. He's got no evidential basis on which to reach that.
Well, he has to make a judgment of what would have happened in the counterfactual situation. That none of these steps have been taken in the period August to January. And in fact, they only started in July. Of course, it would have been a very different situation because they would not have been working for the claimants. They would have been under a great deal of time pressure to get the business up and running. So he had to make an assessment of what would have happened in that very different situation. The burden being on you to establish that what they did on a preparatory basis saved them a significant amount of time.
And we contend that we met that evidential burden because that's
and you want us to overturn the judge's findings in that regard?
Because because for two reasons. One, he didn't have any evidence to contradict our position, and essentially he did ignore all the evidence as to how long it did take.
Can you remind me
Bring
how
these to the
long
party.
you were seeking your springboard injunction for?
I think it was a bit of. I think I was probably.
Can you just remind me how long was you?
I think it was 12 months we were asking.
You were seeking a
But-
12-month springboard.
But I think during the course of how matters developed, I think it became more realistic that it would be a six. What
evidence did you have to justify the 12 months request?
And we were basing it on the fact that there were 12 months covenants, and we were trying to link it.
What relevance does that have?
Well, that was the argument. My lord asked me
So when you toned it down, what evidence did you have to justify
6.
6?
The fact that this had all been going on since the middle of August. The fact that they'd taken from the middle of August to the 10th of January to get where they were on the 10th of January.
which was, as I said, a couple of months for the banking. The SRA, 4.5 months.
Yes, but that was because you told they told the SRA that they were looking at the 6th of January. And that's exactly when the SRA came back.
But you'd have to go through, my lord. I've set this out, and I'm not going to try to summarise it because I don't think that would do justice to the points that I'm trying to make here. At paragraph 14 of my skeleton, I set out in detail.
In effect, I think what you're saying is that the 6-month period for which you ended up asking was justified by the historic timescale to get to where the defendants got to, and that historic timescale should be replicated in the duration of the Springboard relief.
Because that is the advantage that they chose to
Yeah.
seek to achieve for themselves, and which they did achieve.
Yes.
And based on that, based on having spent all that period of time getting themselves to that position by that date, they shouldn't be entitled to benefit from that. And that's there was no evidence, as I say, I'm sorry to repeat it, but they didn't come back and say we could have done all this in 3 weeks.
Yeah. So if let us suppose that a director or employee in breach of obligation takes a lot of preparatory steps which get absolutely nowhere. They produce no results at all. And he spends a long time doing all that. And then he changes tack and takes some other steps which do bear some fruit. You would say that he should be restrained for the period in which he was battling away, getting nowhere, and that was a competitive advantage?
Well, sometimes in order to achieve something, you have to go through a process of failure.
Yeah.
That's the point. You have your first choice and you try to get that because that's what you want, and you don't get it, so then you go to your second choice. But it's a process.
But if the purpose of the Springboard is to prevent somebody from building themselves a competitive advantage whilst employed or a director, you look at what is a competitive advantage, not what failed.
No, but the point I was trying to make was you've achieved that competitive advantage by going through the process of failure, because you might have had to start that the next day you left. You'd have still gone through that process of failure.
Yeah, no, I understand that. Right. Well, I think we've got that point.
Yeah, sorry. So to try to sort of conclude on this, the analysis that he carries out in our submission is a wrong analysis in order to arrive at the decision to refuse, and indeed even concluding that 2 to 3 months. It's almost as if he's saying, well, if it's only 2 to 3 months, it's not really worth it. But that wouldn't in itself be right in our submission. If the objective of the Springboard relief is to deprive somebody of the fruits of their unlawful acts, and they've gained a 2 or 3 month advantage as a result of those unlawful acts, then they shouldn't be entitled to continue to take that albeit limited advantage. That's our submission. And so he was wrong, we say, in the exercise of his discretion to refuse to grant a Springboard injunction, because he didn't take into account material factors, and he took into account factors which just didn't exist on the evidence. He just made his own broad conclusions of what he thought might happen, rather than based on any evidence or any arguments that were actually advanced.
Yes.
I think in terms of the other remaining 2 points, in terms of the grounds of our appeal, I think I can just deal with these by just mentioning them, but without trying to go into them in any greater detail, because the points that come up as I've gone through our appeal on the other points. We contend that there was serious irregularities in terms, particularly, of the judge's approach to the disregarding of the OneDrive.
I'm conscious though that in terms of serious irregularity of that kind, that's probably would be more material if we were looking at a retrial here of some kind, which we are where we are now, and so being realistic. But I've tried to cover those points in relation to where OneDrive would have fitted in, and probably for the same reasons, his lack of reasons, we say that some of the elements of his judgment are not satisfactory from my client's perspective in terms of why he did make certain decisions that he did. But again, I'm probably not going to get very far with pushing that point in the absence of any concerns about retrial. The normal remedy, if you like, for a failure to give adequate reasons might be that the court felt that it's one of those unusual cases where the matter did need to go back to be heard again for a first instance judge to deal with it. But my lords, I put those points in our grounds. There is, but I'm not going to deal with it now, perhaps for understandable reasons. There is a respondent's notice that I haven't mentioned. There's a respondent's notice where, as I understand it, the defendants contend that even if I was right on everything, and I ought to have been entitled to injunctive relief, the principle of clean hands means that I should have been denied in any event, and that's perhaps I can deal with that as and when. I put in written submissions.
Yes.
And basically, we say that this is just not the case for an application of that principle. It's just a non-starter with respect. But I'll come back to that if necessary.
Yes.
Thank you.
Yes, Mr. Grant.
Yes, my lord. I rise rather early than I'd planned, but none the worse for that. May I begin by explaining the proposed structure and approximate timescales of our submissions? This afternoon, I shall begin by addressing your lordships on the legal position.
On
The legal position in relation to preparatory acts. There is now perhaps more difference between the parties than I inferred when I read my learned friend's skeleton argument. In light of some of what he said this morning, that will probably take me most of the time this afternoon until 4:15, whenever you rise. Tomorrow, potentially deal with the law relating to appeals and the facts very, very briefly, which is all it requires, before actually turning to the grounds of appeal. I'm going to propose to take the grounds of appeal otherwise than in chronological order. I can either tell you the proposed order now or when I rise tomorrow morning.
well, your skeleton takes question of relief first.
Yes, I'm going to put that at the end, so I'm not even following the order in my skeleton. The order, if you're interested, I'm going to deal with ground 4, the serious irregularity first, and to the extent to which OneDrive in ground 3 comes within that. Then I'm going to look at ground 2, the findings of fact. Then ground 5, the reasons, because as we shall see, quite often the same paragraph is attacked both in the actual finding and in relation to the reasoning, so it's probably convenient to deal with them in sequence. Then deal with ground 1, which is really the sort of primary ground, the actual liability, before concluding the remainder of ground 3, namely the question of discretion. Then I shall hand over to my learned junior to address your lordships on the respondent's notice. Then I shall conclude with a few observations and submissions in relation to futility, disposal, and the like. And I will be submitting to your lordships that this court does not have the power to make the order which my learned friend seeks to invite you to make, namely to remit the matter back to deal with issues which are not pleaded.
If you're right about that, then
Yes.
all these very interesting other issues don't arise, do they?
No.
So might it not be sensible to deal with that up front?
Well, I'm very happy to do so. The point is simply this: if I can ask your lordships to turn to the white book.
Yeah. Well, we know that Mr. Chastey is no longer asking for an injunction.
No, that's helpful. And
You will have the advantage of us. We are no longer supplied with white books in court.
I'm so sorry, I hadn't anticipated that. I will bear that in mind for next time.
You've got one right at the bottom of your
No, I've only got the supplement. I've got an old one, and I've got a computer. So okay.
Right, well, I've got an old edition here, 2022, which I'll have to do.
I've got an electronic edition if you give me a
That-
moment. If you
No,
give me a moment.
certainly, it's provision 52.20.
That gives us all the powers of the lower court, is it?
Yes.
Yeah.
So page 1874 for anyone who does have a 2024 edition.
Just give me a moment, so I'll get it. I'm just
No, certainly, I'm trying to look at the screens of two of my lords.
You're the same, I'm afraid.
Yes.
Go on, Karen, I'm not going to keep you.
No, I do apologise about this. So, it's the appeal court's powers, 52.20, in relation to an appeal, the appeal court has all the powers of the lower court. Then, subparagraph 2, the appeal court has power to A, affirm, set aside or vary any order, B, refer any claim or issue for determination by the lower court, C, order a new trial or hearing, D, make orders for the payment of interest, E, make a costs order. We're concerned with B, because it's really referring the question of damages back to the High Court. In terms of damages, starting off with the questions asked, I think in combination of my Lords, Lord Justice Lewison, Lord Justice Snowden this morning, the two damages pleaded are the damage for the wages paid or the salary paid to my clients. We say that is a bad claim in law. See the case of Brando, which I'll take your lordships to later on. So they can't realistically, in fact, they can't at all claim for that. The reputational damage, no basis for that, not least because of the secrecy under which my clients are said to have acted. The point the court made this morning. So then it's a question of some other claim for damages as yet unpleaded. We've had some articulation of what it might transpire to be in relation to the increased insurance premium. I don't criticise my learned friend at all, but that's what he's saying on instructions. There's no essence of that whatsoever in the grounds of appeal or the skeleton argument. But it would be wholly improper, I say, for this court to remit a matter back in the expectation or hope or possibility that the claimants may amend their claim to bring such a claim.
But you said we don't have power.
Yes,
We don't have the power to do it.
because it's not an issue or a claim within 52.20 brackets B.
(52.20b).
Refer any claim or issue for determination by the lower court.
Well, there is a claim for damages, isn't there?
Yes, but not of this, not one pleaded, not of this sort. So the only plea for damages so far.
Well, I follow
the
that.
two
I
heads.
understand that
Yes.
you say we shouldn't do this, but
Yes.
shouldn't and couldn't are different
Well,
things.
I have two alternative arguments. The first is couldn't, and second is shouldn't. And I say for all the reasons, some of which have already been ventilated, even if I'm wrong on this question of jurisdiction, it's clearly a very material factor in relation to
Yeah.
whether it would be a proper exercise of the court's powers to send the matter back to the High Court.
And the adequacy of the claim in damages was pleaded below in the defences,
Yeah.
and certainly flagged up in your skeleton argument for this appeal.
Yes, it's not my skeleton argument, but my client's skeleton argument below indeed, yes. Yes, so that's the point I was proposing to take at the end, but I deal with now.
Yep.
And I say nothing more about it for the moment. And turn then to the legal position. So what has now emerged, there are potentially some differences between the parties in terms of the law relating to preparatory acts. We deal with this in our skeleton argument of paragraphs 30 to 50. I'm not going to speak to that for obvious reasons, but that's simply a reference point. The respondent's position is that the law remains as set out by this court in Foster Bryant, that's an authority that wasn't mentioned below, not been mentioned by my learned friend. I'll take you to, in due course, it's in volume 7 of the authorities bundle, which amongst other things partially approves the judgment of Bernard Livesey QC in Hunter Kane Limited. The headline points are these: preparatory acts are not by definition unlawful. The precise point at which preparations for the establishment of another business become unlawful turn on the facts of each case. That is consistent with the paragraph in Shepherd's to which you were taken this morning. There is a spectrum between acts obviously permissible, for example, making the decision to set up a competing business, discussing with friends. On one end of the spectrum, as my own friend would have it, the left hand, and matters which are prima facie obviously impermissible, soliciting customers, carrying on trade, although even that must be qualified in the absence of some other factor, such as consent on the part of the principal, or some other reason as to why those actions are not disloyal. And I'll take you in due course to some cases where the act of actual competition was held not to have been a breach. The respondents say that the judge's summary of the law, paragraphs 311 to 317 of his judgment, is accurate, or sufficiently accurate. You've seen this morning it cites Shepherd, paragraph 313, Helmet, First Subsea, Balston, and British Midland. Paragraph 45 of my learned friend's skeleton argument, those are noted as being cases upon which the appellant relies, although it would appear not entirely so in light of the oral submissions this morning. In my learned friend's closing submission for the trial, the written closing, he set out paragraph 108 of Shepherd's, which you've been taken to this morning. The key bit in that is the precise point at which preparations for the establishment of a competing business by directive become unlawful will turn on the actual facts of any particular case. The respondents also say that the judge was perfectly entitled at 324 to apply the test of settled intention, which we say, and it appears to be no dispute on this, was a clear reference to Mr. Justice Hart's judgment in Midland Tool, and talk of the intention being irrevocably formed. We say, perfectly proper of the judge to have referred to that test, albeit that it may not be a determining indication of whether there has been breach or not. It's a relevant factor, but not determinative. So the ultimate question in any one case is when an employed fiduciary or director is preparing to abandon his principal and commence work for another in the same field, which actions are lawful and which are not? So there is no one answer to that question. Every case turns on its facts. The answer is fact dependent or fact sensitive. You see both formulations of those words in the authorities. In Shepherd's and Foster Bryant we'll come on to, even in Berryland, about which I'll have something to say, and in the subsequent case, Recovery Partners and Rukadze. It all depends upon a number of factors: the nature of the business, the position of the fiduciary, the state of the market in which competition occurs, whether there is a maturing business opportunity. Those are not an exhaustive list, but merely indicative. The seductively simple answer, which it may be that the appellant is seeking to urge upon this court, is that a director or fiduciary must always act in the best interests of his or her principal. We say that that's wrong. Certainly in paragraph 49 of my learned friend's skeleton argument, he says that a fiduciary should always give considerations to the interest of the principal. If that were so, a director could never resign, could never ask for a pay rise. Not every action on the part of a fiduciary is a fiduciary exercise of power. And we've seen the authorities this morning to show that the decision to resign is not a fiduciary power. And in consequence, English law does not bind directors to their principles. I said the fiduciary obligations do not extend to every aspect of the fiduciary's role. I say the true principle is not that a director's interest can never diverge from his principles, but is that the director cannot be in a position where his duty and his interests conflict. And we say that that goes back to Regal Hastings and Boardman and Phillips. It's necessary to consider what the director's duty extended to in the individual situation of any one case and what it did not. In Framlington, one of the earlier cases in the authorities bundle, it was suggested the fiduciary failing to disclose the remuneration he would be paid to a prospective employer was a breach of duty. That submission was rejected by Mr. Justice Blackburn. I can take you to that briefly, if that would help. It's Authority Bundle 5. Tab 28. In the interest of time, I will take you just to where the judge determined the point, and you can see the submission there. It's internal page 497, so bundle 1439. Top of that page, so it's the authority bundle, page 1439, 5 lines down, a new sentence. I mention this because at times during his submissions, Mr. Pymont appeared to be contending that a director contemplating joining a new employer was under an obligation to disclose to the company of which he is a director any unusually generous terms, such as a large capital payment, that the new employer is offering to pay him to secure his services. I cannot see why. We can now put that bundle away.
So what's the context of the alleged breach of duty?
Sorry, I missed your Lordship's question.
Is that so that the existing employer can have the opportunity to counter bid for the services?
Exactly. So we can put that bundle away. The analysis of the Court of Appeal in Foster Bryant demonstrates that there's not even an iron rule that a director cannot compete while still employed. The high time I took your Lordships to that authority. It's volume 7, the authorities bundle. Tab 39. I'm going to invite your Lordships to read the crucial bits of paragraphs 76 and 77, which are page 1866 and 1867. I say that those are perhaps the most important paragraphs for the authorities in the bundle before this court. Given their length, it's going to be far more effective if I use your Lordships to read it to yourselves. So paragraphs 76 and 77, please. I'm grateful for the time. There's a lot in those two paragraphs, and I'd highlight in particular the following 3 points. At 76, A to B at the top of the page, the difficulty accurately to encapsulate the circumstances. That's the fact-sensitive nature, put in a different way. Within the same paragraph, D to E, there is the revival of the personal freedom to compete. So the public policy, which is in tension with the obligation of a fiduciary. You've heard this morning that public policy was raised by Mr. Justice Faulkner in Bolston. My learned friend confirmed that he said his submission, Mr. Justice Faulkner, was wrong. Certainly, he was doubted subsequently in my submission. In Foster Bryant, the Court of Appeal, through Lord Justice Ricks, revived the importance of the personal freedom to compete. And the third point is paragraph 77, between G to H, the desire for merits-based solutions, which explains the wide spectrum of cases. In plus group, where the defendant was in director in name only, there was actual competition while being a director, albeit in name only, and the court in that case concluded, again this court concluded, there was no breach of fiduciary duty. You've seen before, Bolston even was doubted in Shepherd Investment. Clearly, the decision of this court in Foster Bryant should take precedence over that.
Yeah, Bolston is cited a bit more detail at paragraph 60.
Yes, I'm happy to go there as well. So there's a characteristically rigorous treatment of the authorities by Lord Justice Ricks. One can see some of the cases he looked at. So from 59, Island Export, winner.
Yeah.
60s, Bolston. 61, Framlington. 66, CMS Dolphin and Simonet, Justice Lawrence Collins. 70, Implus Group and Pike. Rare case in the Court of Appeal, like novel position. And then on to Shepherd's Investments and Walters. One sees that page 1865, paragraph 74, 75.
Yeah.
And that brings us up to where we are, and that's really the end of the analysis of the legal situation, legal position in that case. The only other point to make, and I think you can put this bundle down for the moment, is the fiduciary's duty to disclose, which may have a greater importance given the way I now understand the Demonor point to be run. It's apparent from, I'm sorry, having asked you to put that bundle away and I ask you to take it back up, I do apologise, it's another case in that. It's the case of QBE Management. It's tab 41. So that was a claim for Springboard relief, but I'm relying at present purposes for a specific point, which is the fiduciary's duty to disclose. And one sees that bundle, authorities bundle page 1906, paragraph 189. I'm going to ask the court to read that to yourselves.
So that's a qualification of Ballston, is it? Amongst other things? Because he
Yes.
cites Ballston at 186
Mhm.
in the passage that you showed us in the judgment of Justice Ricks.
Hmm.
Then he goes to item software.
Yes.
And then he says Ballston is overtaken by it.
Sorry, I missed the last observation, Ronald.
Ballston predates the Court of Appeal in Fasihi and is overtaken by it, he says at 190.
Yes, right. I note that, but I say Foster Bryant is a decision of this court in relation to the public policy point.
Yeah.
And what I'm really referring to here is the question of the duty of disclosure not being a standalone duty, but being an aspect of the fiduciary's duty of good faith. That's why I relate to it here. So the crucial point to take from Foster Bryant is the fact-sensitive nature of it, and the bright lines are to be discouraged in making an assessment of whether any one director in any specific set of circumstances has been in breach or not. To the extent that any of the other cases, including Berrylands, which we come, says something differently, I say with respect, it is wrong. Berrylands, perhaps we can deal with that now before I turn to the question of settled intention. It's in volume 1 of the authorities bundle. Tab 7. Decision of His Honour Judge Hodge, as we've seen. If your lordships can turn first of all to bundle, authorities bundle, page 331, just to see the representation.
Yeah.
So, junior counsel who then was acting for the claimant, the defendants were all acting in person one way or the other. The crucial paragraph is one you've seen at paragraph 23, and I gratefully adopt what my learned friend said this morning, in that that is not a quotation from previous cases, particularly paragraph part 5 of paragraph 23. It's open to some construction as to what exactly the judge is saying there. Taking the steps necessary to establish competing business. Is that all the steps or just any one of them? But the important thing in terms of the status of Berryland as a matter of principle and precedent is as follows. I say that 5 at least is too dogmatic and is not the law, is inconsistent with Foster Bryant. One cannot realistically reconcile the statement at the end of paragraph 23 there with the dictum of Lord Justice Ricks that the extent of a director's duties in particular situations may depend on the circumstances. See, the two are very difficult to reconcile. It's very difficult to reconcile this paragraph 23 with the outcome in Plus and Pike, where there was the actual competition by the director. It's also difficult to reconcile it with the summary of principles by Bernard Livesey QC and Hunter Kane as adopted or recited in Foster Bryant as well. Talks about the factors to take into account will include the factor of position or office held, the nature of the corporate opportunity, its ripeness, its specificness, and the director's relation to it, etc., etc. As a matter of precedent, yes, this was overturned on appeal, but on a different point. So on that basis, it does stand. It has rarely, if ever, been cited subsequently. We have endeavoured to investigate or find any cases in which it has been. Westlaw and LexisNexis both provide no cases citing. That of itself is not an absolute unanswerable position to it, but nonetheless it's a pretty good indication. Not referred to below by either side, we say, but the simple point is inconsistent with Foster Bryant and other cases. But we say ultimately it's this: given the fact-sensitive nature of the inquiry, the factors that His Honour Judge Hodge identifies in Berrylands at paragraph 23 may be in some cases strong, powerful indications of breach, but they're not conclusive. Every case has to be assessed on its own facts. We say that is exactly what His Honour Judge
in any
Bever
event,
did in this case.
on the judge's findings, your clients hadn't done what Judge Hodge describes in subparagraph 5. They didn't have
No.
a business that was up and running.
Exactly. I'm going to come on to that when I get to the part 2 of my submissions. As His Honour Judge Bever said, that, and this is not challenged, in no way, and I'm paraphrasing, was the third respondent ready to trade.
They had no clients, they had
No.
no funding, they had no premises, they had no staff.
Exactly. So even if I'm wrong and everything I say about Berrylands is a matter of precedent and principle, it still doesn't avail the appellant for those reasons. We can now turn back to settled intention, irrevocable intention, and Midland tool. We can put away, actually no, we're in bundle 1. Let's stay in bundle 1, go back a tab to tab 6. And the relevant passage is paragraph 89, page 285. We've looked at this already. The key bit is the suggestion the director who wishes to engage in a competing business not disclose his intentions to the company ought, in my judgment, to resign his office as soon as his intention has been irrevocably formed and he has launched himself in the actual taking of preparatory steps. That passage was described as being potentially too prescriptive by Mr. Justice Etherton in Shepherd's. And we say that it does go too far. My learned friend this morning, this wasn't trailed in his skeleton, but this morning said that Midland Tool even doesn't go far enough. But we say, and I outlined this some 15, 20 minutes ago, that the question of a settled intention or an irrevocable intention is and can be a relevant consideration. That is language which has been used repeatedly since Midland, including Shepherd's, including Foster Bryant, including Helmet, and a case I haven't mentioned so far, Gamatronic.
Well, let's suppose, for argument's sake, that Mr. Justice Hart is correct, despite Mr. Justice Etherton's reservations. On the judge's finding here, and I know it's challenged, your clients formed their settled intention in December.
Late December, early January.
Late December, early January. They resigned on the 11th of January.
10th of January.
10th, was it? And I think they seem to have had a meeting with Mr. and Mrs. Hampson very shortly thereafter, at which they told them that they were setting up a competing business. So those are the facts as found by the judge. So they did resign, and they did disclose in January.
Exactly. The next question is a philosophical one. What constitutes an irrevocable intention? And my Lord Justice Phillips touched on this morning, is whether one can have an irrevocable intention subject to a condition. But it begs the question, and ultimately it's the same points I've made before and will make again, it's fact specific in every case. Imagine a Championship League footballer wants to better himself and find a role in a Premiership club. When does he form the irrevocable intention to do so? Is it when he decides that he wants to play for a better club? Is it when he asks his agent to go out into the market? Is it when that an offer has been made, subject to the medical? Is it when he's passed the medical? That's one example. That won't be true of every footballer. Won't be true of the window cleaner. Won't be true of the lawyers. Everything turns upon its own circumstances. But I say here, I'm jumping ahead now, there is a finding of fact, which I say the appellant simply cannot challenge.
I mean, in other areas of the law, and I'm thinking here of, for instance, opposing the grant of a new tenancy, new business tenancy on the ground the landlord intends to redevelop. The case law says you've got to have a genuine desire plus a reasonable prospect of putting that desire into practice. And that amounts to an intention, a settled intention.
Yes.
I don't know whether that's a useful analogy or not.
Again, what the position may be, and I'm afraid I'm not nearly as close to landlord as your lordship is, but what may be the position there may not necessarily apply across the law and other things. There may well be other instances where a greater or a lesser requirement is appropriate. But here, I said, that test, or the language of irrevocable intention, settled intention, we say no one's suggesting that there's any real difference between the two of them, is language to be deployed. It can be a useful test of what the position is, but it may not be conclusive.
Yeah.
But that's what it is. I mean, whatever it is, it's clearly not synonymous with having a mere aspiration or the beginning of the process. One can intend to do, sorry.
Right, the trouble is, settled intent, put as you did, is that it's a subjective test. I mean, I've just thought in a completely different context. Section 236, examination of directors, which you can't use once there's an intention to bring proceedings.
Yes.
Advance disclosure, for example, get advanced pre-action disclosure. But I don't think it's ever been suggested that it's an entirely subjective test.
You're talking about 236 or the test here?
Well, either or both. In fact, I mean, it's not very satisfactory, is it, to say that it's an entirely. Why would it be an entirely subjective test?
No. One would have to have a regard to the objective evidence and the documentation, and then say, parting say objectively, their intention was reached then. But again, there's no challenge by the appellant here to say the judge misdirected himself by adopting a subjective test as opposed to an objective one. In each case, the trigger for turning an intention or aspiration into an irrevocable intention will change. It might be the indications potentially here from the SRA they'd be likely to improve. It might be the confirmation of other factors. It could be nothing from a business perspective, but a personal resolution of someone after Christmas saying, actually, I cannot stand this any longer. It could vary tremendously. One would have to assess it in each individual case. The last point I wanted to make in terms of the legal analysis is when is a business opportunity maturing? Now, this may have diminished importance now, given the way my learned friend characterised the Demonor point this morning, which may be the high watermark of the appellant's challenge. But I'll deal with this, if I may. Maturing as an adjective to business opportunity is language which is well established in the cases. One sees that, I'm not going to do a report to all the cases, but one sees that, just for your lordship's note, in amongst others, Island Export, Bulston, through Foster Bryant, as you've seen, and most recently, at least what we have in the bundle, And what I'm going to suggest is the best definition, which is Recovery Partners and Ricadsi, decision Mrs. Justice Cockerell. That's an authority bundle, volume 8. No, I do apologise. It's bundle 7, tab 44. I apologise.
7 tab.
7 tab 44, my lord. Now just lighting on the head note for the moment on page 189, by hopefully the second punch hole, the last full line to the reference to maturing business opportunity. But I'm really going to take you to paragraph 60, which is on page 2005, 2005.
This case went on appeal.
I beg your pardon?
This case went on appeal.
It did, yes.
But didn't touch on this.
It didn't touch on this, no. Paragraph 60 is the paragraph invite the court to read itself. A description of when an opportunity may be regarded as maturing. And let me read on to paragraph 62 as well.
Buller and Buller doesn't fit what the judge says at 60, I don't think, if I remember rightly. It doesn't have to be contact. Buller and Buller was the case of a director who got wind of a development plot next door and just took it. The company didn't know anything about it.
Well, that is true, but and that's partly what doubtless why she refers to the controversy in relation to it. But the paragraph I invite the court to focus on, paragraph 60, where quite rightly her ladyship disavows any regimented requirement having regard to the language of Foster Bryant. But it's lines 3 to 4. The third party with regard to future business, and that contact has progressed to the stage where some outlines of future contractual relations are in play. So that is the test, and if it is, I say the facts of this case don't come anywhere near it, for obvious reasons.
Sorry, we're looking at this in terms of what? Deminor?
Well, principally, yes. Because it's difficult to see what else could be the maturing business opportunity on the facts found by the judge.
Why do you say that Deminor, or at least the opportunity or the possibility of some future relationship was not in play before the 10th of January 2023?
Because it had been rejected. I was going to come on to Deminor tomorrow and deal with the facts of it, but in very simple terms, Deminor's interest and desire to fund was rejected at least once, if not twice.
But isn't that looking at it from the wrong end of the telescope? So I thought when I was having my debate with Mr. Chasely that the position with Deminor is that Deminor was really not an opportunity for CEL, because CEL had its own funder that it was perfectly happy with, which was Augusta.
Well, I have lots of other factual answers to that, which I'd prefer to deal in context tomorrow. And I can deal with them now, but it will make more sense if I deal with the Deminor point tomorrow. In terms of, just to give your lordships, I'm not ducking the question, the presence of Augusta, what evidence there was as to whether Augusta would have terminated, whether Deminor would have declined any approach to them and the like. And that's only some of them.
Because I mean, what Mrs. Justice Cockrell goes on to deal with in this passage that's sidelined is the sort of the area that I've just been putting. I was really debating with Mr. Chasely this morning about the circumstances of what, where, for example, the board has decided not to pursue a particular opportunity, in which case it ceases to be a sort of anything to which the company has any claim and can hold any fiduciary to. This is quite independently of the way Mr. Chasely also put it about the damage arising from the termination of the Augusta agreement, etc. So I understand we're on this point, which is that if I think I mentioned this morning Visa Silver Mines, which I see gets a little mention there, that's the sort of case that says that where, for whatever reason, the company's decided not to pursue an opportunity and to go with somebody else, then it's no longer a problem for the director, subject to a lot of other things, but it's not a maturing business opportunity. That's not the problem for a director. And the director may be under other restraints in what he does, but it's not to be regarded as contrary to this line of authority.
Exactly, and using the language of Mr. Justice Cockrell, paragraph 66, second line, it's not an opportunity which is actively pursuing. That's another way of putting your lordship's point.
Then, but she does say at the end of 67, I conclude that whilst active pursuit would be fact sensitive, cases indicate that a clear disassociation of the principle from the opportunity will be necessary. And that's tied in with this question about whether the consent, it's normally the way this normally works is that, like Queensland Mines and Hudson, for example, you've got an opportunity, the board decides not to pursue it. The director keeps quiet about his own idea that he might like to, and the board decides by majority not to, and then he goes ahead and just grabs it for himself. And that's said perhaps to be on the wrong side of the line, because there was no fully informed consent when the board decided to go with, sorry, to pass up the opportunity. My understanding on the facts of this, and I appreciate you saying you're going to deal with it tomorrow, is that the decision to go with Augusta rather than Deminor was reached very early on the piece. I think it was April. And nobody's suggesting that that decision was influenced or in any other way inappropriate one for the company to have taken. And having decided to go with Augusta, it was prevented, I suspect, from going with Deminor.
Having decided to go with Augusta, it decided it didn't need to go with Augusta.
Well,
Yes, we can.
be very, I was working on the assumption of, maybe I'm wrong, that if you go with Augusta, you're not going to be able to go with Deminor as well.
We'll check that position and have an answer for your lordship for tomorrow.
I suspect the Augusta agreement.
Yes, it may well be exclusive. Yes.
That's wrong. I probably ought to tell them.
I would suggest that the whatever the factual position is here, so we'll address tomorrow, that the question of fully informed consent is perhaps the best way to look at these situations. And that would distinguish between the Buller and Buller case, where the company, the principal didn't know about it, and a case where they knew about and decided they weren't going to pursue it.
And pursued something which meant that the other one was just off the table,
Yes.
potentially just off the table, practically or legally off the table.
My lord, that concludes the legal submissions in relation to preparatory acts. I'm entirely in your lordship's hands whether I deal with challenging findings of fact, which will take me all of a few minutes, and then potentially keep going after that, or stop now.
Well, how long are you going to be on challenging findings of fact? I mean,
3 minutes?
right, well, let's have that now.
Yes.
So we're revisiting Volpe and Volpe, are we?
Yes, that's the third of the three cases of your lordship I'm going to refer to. Yeah. So the cases are.
I think you can take it we're pretty familiar with the principle.
Exactly, it was the principle. So all I was just simply going to take out Volpe and Volpe because it's also referred to Lewison. Bundle 8. Tab 46. Page 2206 of the bundle, and I will invite your lordships to refresh your memory of what my Lord Justice Lewison said of paragraph 2, rules 1 to 6.
Have you got sprint room somewhere?
Sorry?
Have you got sprint room somewhere in this?
No, we don't actually. We took the words of your lordship of paragraph 3, face value, if authority for all these positions is needed, it may be found in. So we decided not to overburden the court with authorities on the point. But the key point, which should be uncontroversial, is a high threshold for an appellant to make challenge on findings of fact, whether they are of the binary sort, the car was red rather than the car was yellow, or whether it's the evaluative question, which is rather closer to the table here. And in the course of tomorrow, one of the things I will seek to do is to show to your lordships the vast number of factual findings made by the judge which are unchallenged, many of which are either individually or collectively fatal, we say, to the appellant's challenge. My lord, I can turn to the individual grounds or pause
We
there.
might as well have another. Well, we don't normally rise till 4:15.
No, well,
so
I'm happy to keep going. I mean, we
So
are
let's-
ahead of where I
let's
had
carry on.
anticipated, but that's no reason to stop. May we start by turning to the core bundle, tab 1, page 1. These are the grounds of appeal. I appreciate the court has looked at these. It's helpful, I suggest, to look at them again in light of the oral submissions this morning. And again, I can repeat my proposed order of submissions. Use speed. Ground 1 is challenge and perverse wrong findings in relation to all the claims being advanced and the relief in the form of injunctive relief at 4. And it is said these findings were wrong in law and or were perverse because on the basis of the evidence in the case, no reasonable tribunal could have reached such decisions, and he ought to have held that respondents had acted in breach of such duties and obligations, had committed such tort of conspiracy, and ought to have granted the injunctive relief claimed. Ground 2, on the face of it, 6 aspects of findings of fact being challenged. According to the skeleton at least, and we didn't really get into this today, A hasn't been dealt with under the heading of finding a fact. And point 5, I think, also is not challenged or isn't addressed in the skeleton argument. So we're down to 4 findings of fact. And in due course, I'll take them through and say why in each of them the finding by the judge was entirely unimpeachable. And the reason has been said that the findings of fact should be disturbed. It's at the bottom of that page. The findings were wrong because the learned judge failed to take into account the full evidence before the court and failed to take into account material circumstances and material probabilities. Now, as an initial point, I say that doesn't come close enough to the test in Volpe. The mere fact that a finding is said...
Which of these 6 are you saying were ultimately challenged by?
Well, according to the skeleton argument, it's 2, 3, 4 and 6. Some of these points are also the subject of reasons challenge. Again, we've heard precious little about that today. I'm going to go through all of this in sequence tomorrow.
Are you saying that, I mean, A is not really a finding of fact?
No, and that's doubtless why it's been sort of put into the different part of it. And 5 said isn't the subject of any treatment in the skeleton argument. But in relation to finding of fact, although it is treated in relation to reasons under ground 5.
We didn't hear anything orally from Mr. Chasey today on 4 or 6 either.
But I'm going to...
So the key area where there's some factual issue taken, I think, is 2 and 3.
Yes.
I mean, that's really the core of what Mr. Chasey said. I mean, 1, the judge was wrong to say well, first of all, he said settled intention isn't a test, but if to the extent it was, the judge ignored a whole load of stuff that suggested that they'd had a settled intention earlier than the judge suggested. And putting aside, or focusing on Deminor, the way he, I think, put it most strongly, as you acknowledge, is that there was a conflict because there was a risk of some harm to CEL's interests arising out of the intention that the defendants had to go and jump into league with Deminor.
And I'll deal with the merits of those grounds tomorrow. I'm just going through. Ground 3 is the discretion. It comes in 2 points. The first bit is the pertains to the injunctive relief. It's the finding by the judge that even if liability had been made out on one or more of the claims, fiduciary duty, breach of contract, conspiracy, nonetheless, he wouldn't have been minded to exercise his discretion to grant an injunction. The second part of this relates to the OneDrive point, but I'm going to say that's really subsumed into ground 4A, which is one of 2 points, 4B being the other, which is said to give rise to a serious irregularity. 4A, that's the OneDrive evidence point, and I'll deal with that. 4B, saying that the judge was wrong to proceed in the way he did in relation to the unlawful means conspiracy, in particular in finding that there was no loss. So he said that this was a part 1 of a split trial. Now, we haven't heard anything about that this morning, but I'll deal with it hopefully briefly tomorrow. And the final ground is ground 5. Simply said, the learned judge failed to give any adequate reasons in respect of his findings. With respect, that does not discharge the function of grounds of appeal. It doesn't tell you which reasons, which paragraphs. One has to look to the skeleton for that. There are 9 examples given. It said 4 overlap on the face of it with findings of fact, so it's an alternative basis for challenging what the judge says at the relevant points. The others are new and additional ones.
My understanding is that Mr. Chasey accepted that as he wasn't proposing that there be a retrial, that grounds 4 and 5 didn't really take him anywhere.
Well, that's certainly what he said. and I'm going to reflect exactly as to what, if anything, I need to say in relation to them.
Like for myself, I took that to mean that he wasn't advancing them.
But certainly we've heard quite a lot about the OneDrive, and it's really in the context of that irregularity point. So I feel required, if I need to discharge my duties to the court and my clients, to deal with the OneDrive point. The reasons I can perhaps deal more briefly, and it may sort of encompass what I'm going to say about the findings of fact themselves.
Well, OneDrive, as I understand it, OneDrive is predominantly advanced in relation to ground 3.
Yes. Yes. It's an exercise of the court's discretion, but it was no relief was sought. It's different conceptually to the question of an injunction. And that's why I say it's better analysed through the prism of ground 4. But however I deal with it, I'm going to deal with it and say why what the judge did in relation to OneDrive was perfectly acceptable and proper to him. My lord, I'm happy to start on the actual detail of the grounds, but I won't finish the first one.
Well, I think in that case we will. How long do you think you're going to be in your submissions?
Good question. I would say are things being equal between an hour and a half?
Oh, I see.
Yes.
Right. So we'll finish comfortably tomorrow. All right. We'll
And
break.
then of course, that's a sort of total figure, including I think my
Respondents'
Mr. Baker as
notice.
well.
Yeah,
Respondents'
all right.
notice.
Right. We'll break now. We'll resume again at 10:30 tomorrow. Thank you very much.
Oh, right, you very well.
I'll call you a bit loosely.
So, Nicola,